or because of the British rule was that 1885 legislation, Telegraph Act. As I said, it was challenged on various counts, on various grounds in different litigations. We are going to discuss some of the litigations as well. But understand this, that the very ethos remains same. You are not going to challenge it prior to independence or prior to constitutional era, but definitely post-constitution, you had valid grounds to challenge that provision under section 5 of Telegraph Act. Now see the difference, how exactly it meant. We had a law prior to constitution which got into surveillance. Today also we have it, but at least that scope for challenging that particular provision on the grounds of privacy, it does stand, it is there. Generic sense of privacy, we have many things which are imbibed into it. The famous example, very old one, Kharak Singh versus Union of India. No, sorry, it was not Union of India, it was state of UP. State of UP. UP police regulation was challenged. Rule 239 and Rule 245, these were the two rules which were challenged. Any offender under UP police regulation who is granted bail was supposed to have a daily attendance in the police station. There are few provisions regarding that also, that 245 says it, that at least in a week's time the person must be present who is involved in a crime and possibly is an under trial but has been released on bail. He must have made some kind of bail and bond, which is a very much provision there under CRPC. But this particular provision allowed one more provision, one more procedure, that if a person is not coming in police station on a daily count or possibly in a weekly time, even police are allowed to go and actually vigil the concerned person with their own convenient time, just to see whether the person is within the vicinity of the police station. I hope you are all aware with the Criminal Procedure Code, which says surveillance, or rather as a matter of search and seizure as a procedure. They will just come and see whether the person is available or not. There are few restrictions sometimes posted because of the nature of the crime of the person. He is not allowed to go beyond the country, or possibly he is not allowed to go beyond the state, something of that sort, right? It's very much there as a matter of procedure. So what happened to Kharak Singh was, Kharak Singh, he had a genuine problem with the police coming to his place and just seeing whether he is there or not. I mean, there was no procedural situation that police can't do it, but the problem of Kharak Singh was different. These domiciliary visits of police were deliberately conducted at wee hours at night. Imagine, suddenly at 1 o'clock at night or 2 o'clock at night, police coming in and just saying this, whether Kharak Singh is available or not. And even if he says so, yes, he is available, okay, fine, then you can sleep, no problem. We just came to just see whether you are there or not. He agrees that, okay, fine, I am a criminal, or possibly at a subsequent stage I might be proved to be a criminal. But currently this practice, this procedure violates my fundamental right. So quite natural, we need to look into it as a matter of practice, that how we are going to see it. Quite natural, it's not a factor that all the time you will read it in line with that, but still it's domiciliary visits which got challenged into it. And obviously courts held that this is not done, this is something which we do not expect, and obviously it was stated to be violative of fundamental rights. Subsequently, another case came in where all this ambit of privacy as well as all these issues related to Article 21 came in line. No doubt I'm going to deal with certain aspects of telecom also, especially in line with that particular provision, section 5 of the Telegraph Act as well. But just to give you a hint as to it, up to what extent we can go into liberty constitutionally. It's not just about that one simple factor that which you might relate it only to telegraph, but some other areas would also encompass that. Other than that, you might be also aware of Bhim Singh's case, Bhim Singh versus Union of India, where an MLA of one legislative assembly was stopped from moving in one particular direction. He was going to assembly only to attend the session, and he was denied that only for one reason, that there is some case going on and we need surveillance, we need to check search seizure. So in Bhim Singh's case also the same thing was established. Article 19 as well as Article 21 came in question, right? Similarly, if we see the overall constitutional ethos or possibly whatever judiciary has done in the recent past, or rather even in the past, I must say that they tried to see to it that the constitutional provisions are given more importance. There is no challenge as to it, quite natural. But still, Section 5 of Telegraph Act is something which is different, because it is not read in isolation, it is read rather in context with public safety and public emergency. Now, how this whole issue comes in and how we are trying to read it in the ethos of the constitutionality and specifically privacy. We have many instances where this has been done. The initial judgments, 1974, if I say, was an year of a little miraculous situations where both public safety, public emergency was taken into consideration, and it was said that even if that is happening, we are okay with gauging upon the privacy of the person. Now see how exactly it happens. 1974, those days, long time back, even then we had a judgment which was passed in Hukum Chand versus Union of India. It's 1973, 1 SCC 289. Hukum Chand versus Union of India. 1973 in bracket 1 SCC 289. That is the citation. In this particular case, the whole issue was as to that agri-based, products which have been on sale, and what they used to do was they used to conduct a kind of bidding onto agricultural commodities. Now, popularly in our Hindi or possibly in vernacular language, they call it satta. Determining prices of certain commodities which might affect the market or market condition. For example, if lobby of certain wholesalers decides among themselves that we are going to create a natural scarcity of one product, automatically the prices will go up. That's the usual economic situation. Demand raises, price rises. That's the common phenomena which we understand by common sense, right? So obviously the fact was that all this was conducted, and for such kind of communication and lobbying, the very basic mode which was used by these traders or these people who were creating the lobby was nothing but telephones. So quite natural, their communication was intercepted first. To track them up, there was no other evidence. So what police or investigation team did was, they kept a surveillance and they actually used that communication which was intercepted for the purpose of evidence. They said that the lobby was created and there were certain constructive pieces of evidence in the form of telephonic conversations of parties, where it was clearly mentioned that yes, we will affect the prices by higher bidding, lower bidding, or construing the commodities at one place. That's how it all started. In defense, Hukum Chand and all of people who were involved into lobbying, they said that this is breach of our privacy, because they now were a little scared that if they are booked under that criminal law, they would be sent to jail. So instead of being a guilty for one particular set of offense, they tried to use that as a matter against the police. They said the very inception of this idea, interception, is illegal one, because we are breached with our privacy. It's a constitutional right getting breached. So it's not done. It should not be done. The court came in with a very big logic as to it. Justice Sarkaria was the judge in that particular case, who said, yes, we respect the privacy of the individual, and obviously in the current world, I mean, he's talking about 1974 situation, imagine 1973 situation. He said that we respect the dignity, privacy of the telephonic communication of the person, but not at the cost of public safety. These two words, public safety and public emergency, are repetitively used in this Telegraph Act. And somewhere you might feel that there is more interpretation required for these two words. That happens in Hukum Chand also. There is another judgment which came in after this 1973 case. R.M. Mallar, M-A-R-R, Mallar, versus Union of India. Again, Hukumchand was taken into consideration in that judgment. I mean, R.M. Mallar was almost the replica of the judgment, but again, emphasizing more onto this aspect, 5.2, section 5, subclause 2, which defines what is public emergency and public safety. These two angles, these two words, these two terms were discussed in that. Now, R.M. Mallar, we had a very different situation altogether, that, it re-established what was done in the previous case, plus it also stated that, what could be the grounds when you say public emergency. Now, for many people, public emergency would start and end with terrorism, anti-national activities and so on, right? But it's not the only area where you need to constitute yourself. There are so many other factors also which may come in question. Why? Because of the very reason that it may not necessarily be only a terrorism as an act which you want to survey, or rather you want to have a surveillance or monitoring. There is something else which could distract public peace, which could distract public safety as well. For example, economic imbalance, targeting economic organizations with lobbying, or possibly a communication that would raise some kind of inconvenience to parties who are actually making decisions, policy decisions for the public at large, especially in the economic sector. If that is considered, we may say that yes, even an economic crisis created by virtue of communication or possibly by way of mass communication would also tend to become public emergency. It can be, right? Terrorism necessarily does not mean all the time to bring out the gun and start with any kind of an activity which involves more of physical force. Might not be necessary all the time. We may have certain set of activities which are absolutely beyond the scope of that. May happen that a person is not using any kind of physical force, but uses his brain or uses his communication to commit an economic crisis or create an economic crisis. May happen in that way. They tried to read certain things in R.M. Mallar, that what could include or what will be included in the concept of public emergency. And they stated this, that the matters related to public safety, public health, economic, national economics, all of that would come under that purview. And specifically, if I mention paragraph 21 of that judgment expressly mentions that how to deal with that concept of public emergency. It's quite significant approach. Even Sarkaria's intervention into that, the earlier judgment, also states the same thing. That it cannot be defined by virtue of few words, but we need to read it in context. It may be a public emergency kind of a situation depending upon grave emergency occurring for public safety, public issues, or for that matter anything which you can see under the sun. If really is, we allow surveillance into it. That's how it is seen. The only issue then comes up is, are we really sensitive about the rights of people involving privacy, and that too through telephonic communication? I hope you are again very much well versed with the judgment which came in PUCL versus Union of India. Aware of it? Public Union for Civil Liberties. India is party, by the way, to that Civil Rights Covenant which we have, which encompasses area of privacy. So obviously we are respecting the privacy. And this judgment, possibly PUCL versus Union of India, is the modern judgment which actually defined the terms in respect of privacy, that too with electronic devices, gadgets, and this Telegraph Act. Hope you know the year. 1997 was the year when we had this particular judgment. 1997, 8 SCC 1328. That's the citation. Well, this particular case gave a great imbibe onto this fact that how do we judge or whether it is validated. I mean, obviously privacy getting breached by way of surveillance and monitoring. One must understand one factor, that wherever that law is coming into force, wherever Telegraph Act coming into question, the first necessary requirement is the act doesn't allow breach of privacy just for the sake of privacy. They have given that ground, public safety, public emergency. The same issue came in PUCL, where certain set of people targeted this issue, saying that, see, stings or